I'm equally so happy to introduce Mr. Anil Mundra, who of course doesn't need any introduction, particularly in the domain of the family matters or family law as such. I've known him since 1980 as a student, as a co-runner in the profession, and as an author. He argues cases, writes authors, books, and this combination, that his books are based upon the cases that he has argued in the other cases as such, enriches the legal literature, particularly in the domain of private law. I've been associated with his books in one form or the other. And therefore, the experience that he brings in would go a long way in generalizing this particular workshop relating to the family court matters. Thank you so much, Anil, for sparing your time to be with us this morning.
A very good afternoon to you all. Honorable Justice Ritu Bari, my teacher, Dr. Balram K. Gupta, whom I affectionately address as Lord Denning, and legal guardians of families. At the outset, I'm very, very indebted and grateful to Honorable Justice Ritu Bari, who has, ever since the inception of the High Court, taken the step forward of reorienting the rules for the family courts. And I owe this training, I owe this discipline to the Karta of the Kopassanary of Judges, Justice A.L. Bari, father of Justice Ritu Bari, who continues to guide us in his ripe age of 90s and has always been a source of inspiration to me as a young lawyer who joined the bar in '85, and his path-breaking judgments on whatever jurisprudence he dealt with was always the guiding path for judges and lawyers. Now, before I enter into the arena of limping marriages, as I call them, which Satya versus Teja Singh identified 42 years ago in 1975, I pose some questions which I, as a mechanic with a toolbox, lug around all over the country and which have arisen to me. Now, every morning when I see for 5 newspapers, I find in them scores of advertisements of substituted service, trying to serve erring spouses in Italy, in Germany, in Canada, in Sweden. And then every day I look at the CPC and I wonder to myself, why do we resort to Order 5, Rule 20, which talks of substituted service? Why have we not changed to Order 5, Rule 25, which came in after the judgment of the Supreme Court by Justice Sabharwal, where service was allowed by courier, by email, by fax, and other alternative means? My proposition is, when a marriage is limping, it needs to be resolved. When you pose a newspaper notice, it takes 3 months or 4 months before anything gets anywhere. And who is reading Tribune, Pioneer, or Chardi Kala in Italy, Germany, or France? So I seriously think that the High Court rules should incorporate a provision at par with Order 5, Rule 25, which says that where the defendant resides outside India and has no agent in India empowered to accept service, summons should be delivered to him at the place where he is residing and sent to him by post or by courier or any method approved by the High Court, by fax or the electronic mail service, to be, as the High Court rules may provide, if there is postal communication between the place and institute outside. So we seriously need to change this concept, outmoded concept of substituted service by newspaper notices, because I honestly, to me, it's only a prolongation of a misery which doesn't serve any purpose. So this is one humble suggestion I have. The second glaring issue which I find often in limping marriages is a domestic violence petition cannot be filed in the family court because the jurisdiction is under the Prevention of Women from Domestic Violence Act 2005. But what happens if there is, let us say, in one court in Chandigarh or in Punjab or in Haryana, a domestic violence petition before a judicial magistrate and a same list between the husband and wife and the child in the family court? Can they be clubbed? The question has been taken by me recently to the Supreme Court, but this is an inconsistency which will need to be resolved at some point of time. The third issue which I find in limping marriages is that the spouse who comes to India, sometimes the woman, takes an interim custody order under Section 21 of the Prevention of Women from Domestic Violence Act. So the foreign court wants to know, is this remedy conclusive? The answer is in the Prevention of Women from Domestic Violence Act, because it says the independent remedy is available, and the substantive remedy is under the Guardian and Wards Act or the Hindu Marriage Act or the Special Marriage Act, as the case may be. The second is parents, spouses come complaining that the order of the family court has not been complied with. Is execution the only answer? Or does the power lie with the High Court to issue contempt under the Contempt of Courts Act? Because under the Contempt of Courts Act, Section 10 says that the High Court can take notice of the court's contempt or violation of the subordinate courts also. But how many have been filed? How many have been entertained? So there is something in the rules which probably will need to cover this as well. Then another issue which probably can be addressed in the rules is, if there are interim orders passed by the family court which are not appealable under Section 19 of the Family Courts Act, how are they to be challenged? In Bombay, they are challenged by a writ petition under Article 227 of the Constitution. In our court, they are challenged under 227 and they are tabled as a civil division. So I think some nomenclature to define the challenge to the interim orders would be necessary, because under Section 19(4) of the Family Courts Act, interlocutory orders cannot be challenged under the Family Courts Act itself. Now, with this brief introduction, I now come to an area which I will speak minus judgments, because eminent speakers before me have led to you a rich knowledge, a data bank of citations on probably every aspect. So I would not wish to repeat, and I would not wish you to be burdened with more citations. I have circulated a concept paper in which I have given all the citations. My 9th book, Global Indian in the Law, contains a plethora of law, but I will talk to you about human beings, lives, because you are guardians of families. You are not family court judges. Your purpose, your laudable goal, your pious duty is to bring harmony into the home. And I'm very happy to see that there are such large number of energized young officers who are manning and donning these posts, and they are treating this as something of a conscientious duty which they must fulfill to achieve the lofty goals of the Family Courts Act. Now, guardians of families, we are a population of 1.3 billion. Now, approximately 30 million of us live in about 200 countries, and we are labeled as overseas citizens of India, persons of Indian origin, or plain and simple NRIs. India itself is spread over 3.28 million square kilometers. to about 29 states and 7 union territories. And for me, as a mechanic with a toolbox going to a family court in Goa or in Chennai or in Bangalore, even that jurisdiction is alien to me. But it is the Family Courts Act which gives the umbrella, which is a central model to bring together a resolution dispute forum, which has come in late but still has been introduced in our jurisdictions. I would often find that there was a family court in Punjab or Haryana or in Chandigarh, but because it was not notified, the district judge was still referring matters to the subordinate judge, if it was the Guardian and Wards Act petition, or a matter was going to the ADJ if it was a divorce petition. That resolution is, of course, taken place now. But then the biggest dilemma, which is now creeping up because irretrievable breakdown of marriage is not a ground for divorce, is what do you do with the foreign divorce decree which is before you? So I think we need to first understand the basic concept that once parties are Hindu by religion, irrespective of whether they are Germans, Canadians, Americans, Britishers, or Australians, they have a different passport, they have a different domicile, they will remain Hindus by religion. And the Hindu Marriage Act, Section 1 and 2 says that the Act has extraterritorial application. So this means irrespective of your domicile, irrespective of your nationality, irrespective of your citizenship, you will still be Hindu by religion. What does this effectively mean? So if you have a Hindu marriage solemnized under Section 7 of the Hindu Marriage Act by performance of Saptapati, and we all know registration is optional, it is a conclusive Hindu marriage for all intents and purposes. Now, the law laid down by the Supreme Court in Narasimha Rao's case is that Hindu marriages solemnized in India according to Hindu law can only be dissolved by a court of competent jurisdiction in India. Mirja Saraf's case went a little far to say that there should be a statute to this effect. But the fact of the matter is that this is a concept which has been explained further by Justice Rajiv Raina, whom I had the benefit of assisting as an amicus in Rupak Rathi versus Anita Chaudhary. Now, this was a case of a young couple from Haryana who had gone to the UK. The wife participated in the husband's petition for divorce by irretrievable breakdown of marriage. You all know irretrievable breakdown of marriage is not a ground for divorce in India. And at some point of time, she withdrew from the litigation and initiated a divorce petition in the family court, or it was a district judge at that time in Panchkula. The husband walked up with the matrimonial decree dissolving the marriage by a decree of divorce. In England, there is a decree nisi and there is a decree absolute. Decree nisi is granted for the asking. Decree absolute is made when you settle matrimonial property and custody of children. So when decree absolute was presented before the district judge in an application by the husband, claiming that the court had no jurisdiction because the marriage had been dissolved, the court dismissed the application and the matter came up in revision before the High Court. And the High Court expounded the principles laid down in Narasimha Rao's case. And the bottom line was, which is a very useful elucidation of the law, it says the validity of a marriage decree of divorce by a court of foreign jurisdiction will be tested on the anvil of Section 13 and 14 CPC. So if any of the ingredients of a marriage under Section 13 and 14 CPC is not satisfied or the exceptions fall in, then the decree is null and void. So the straight answer is, if it is a decree of divorce on irretrievable breakdown of marriage, it is no good, it does not serve any purpose, and the court is bound to reject the decree of divorce. What next? So the answer is, if an application under Order 7, Rule 11 CPC is presented to you, seeking to dissolve the marriage on the preliminary ground of maintainability, you are free to reject it, saying it is not a valid marriage. And then what do? You will have your own pleadings, you will have your own substantive petition, you will have the evidence, you will coin issues, and you will decide. And the foreign decree may be one part of your conclusive decision if you wish to go into on merits. Now, on another note, which I will address tomorrow, is the procedure which a family court ought to adopt in a matrimonial proceeding or a guardianship proceeding. And this has been expounded by the Supreme Court by Justice Khanwilkar in a brilliant, illuminating judgment where I had the opportunity to assist the Supreme Court on what should be the procedure in a family court. That we will take up tomorrow. But coming back to the discussion. So you as the family court, under Section 12 and Section 14, I would very, in a nutshell way put, you are the Chief Justice of your own court. After you comply with the substantive procedure of the Family Courts Act, the Hindu Marriage Act, or the Guardian and Wards Act, you are free to devise your own procedure on what you have to do, on how you will handle the proceedings before your court. I've had the opportunity of conducting some matters in Delhi, where I find that the family court judges with seniority and age and experience have come out with very illuminating ways and methods of recording evidence, of coming down to issues, taking documents not admissible under law of evidence, breaking away from the shackles of procedure. And I think one way of breaking away from CPC is the substituted service. You are free to adopt an email, which of course is an option available to you under CPC also. But my humble suggestion to you as a practitioner, because I am perhaps the only person amongst you all who's on the other side of the fence, is please decide expeditiously. Please decide whatever you think is right or wrong. You lay down the law. Supreme Court does not lay down the law. Supreme Court will only affirm or reverse what you will lay down as the law. So you are the makers of law. Unless you apply your mind, unless you think in an innovative way, you think out of the box, which liberty is given to you under Section 12 and Section 14, we will not be able to evolve law. The pandemic in 2 years has multiplied, and there is an explosion of family law litigation. I happened to do a webinar with Justice Hema Kohli and Justice Alistair MacDonald of the High Court of London, of the Family Division. And the view was unanimous that COVID has taught us to come up with new measures in new times. We have to cull out methods whereby we can put limping, we can dissolve limping marriages, or we can put together spouses in limping marriages. So in this larger perspective, I have seen two developments which have taken place in the Maharashtra jurisdiction, particularly the Bombay family court in Bandra, where there are 15 judges in one building. The principal judge has 14 additional judges, and he has appointed child independent lawyers to assist him in proceedings wherever there is a child. Because every litigation between spouses of parents for child custody is treated as a divorce petition. It is more of a battle of contest of the rights of parties. Who looks at the child? Nobody. So there is a voice of the child, there is a right of the child to be heard, and who projects it? Child independent lawyer. So if using this facility which is provided under the Family Courts Act itself, under Section 12 and Section 13 to have an amicus, I am free and available to any family court to assist as an amicus online whenever anybody needs me. But please do try and generate a breed of amicus lawyers to assist you in your jurisdictions. Among the younger generation, there is a bright spark of lawyers as well who will be able to assist you. And if you can build up some specialist family law lawyers in your jurisdiction to assist you, limping marriages can be put dissolved in a more amicable way. Now, let's get the bull by the horns. What do we do with foreign decrees, and what do we do with jurisdiction of foreign courts and family matters is the topic which I have been asked to address. Now, the problems which I am asked to answer in view of an expert report as an expert evidence in foreign jurisdictions is, what is the validity of a foreign divorce decree? I am often instructed by spouses to ask, I have a Hindu marriage and I have an American civil marriage. Where do I file a divorce? I have property in both jurisdictions. How will we dissolve property? Are child rights decided in one jurisdiction conclusive in India? Now, these are questions which come because 30 million people have moved up and down and have habited foreign countries. The sad part is they don't want to start litigation in India because everybody thinks it's going to take very long. I often tell them, you need to find a method out of the box. We can solve the problem. So let us suppose you have a marriage which is broken down and in which there is a foreign divorce decree. Now, to the extent the foreign divorce decree dissolves the marriage if one has taken place in the US by civil rights, that dissolution of marriage is good for that civil ceremony. Insofar the Indian marriage is concerned, it has to be dissolved in India by a court of competent jurisdiction. Now, the nitty-gritty is, how do we do this? Law has developed. Justice Ritu Bari very well pointed out that the High Court has not only permitted dissolution of marriages online, it has also permitted registration of marriages online. I think we are probably going to expand in this jurisdiction with this enlightened view, and Justice Ritu Bari heading the Family Court Committee, where we will have a new set of propositions coming forth. So the advice given to parties is, you are still going to be married in India. So what is the answer? The parties turn around and say, there is one petition under the Domestic Violence Act. There is one petition under 125 CRPC. There is also an FIR under the 406-498A with the Dowry Prohibition Act. There is also a guardianship petition. So there are, let us say, 5 or 6 litigations which are pending in India. They will not come to an end if you dissolve the marriage. So the consensus advice to the parties is, you draw up a settlement in the US court, laying down what your marriage has in India to be dissolved. And after the dissolution of the marriage, subject to whatever happens in India, keeping back the separation of matrimonial property and child custody issues at abeyance, so that pressure is there to resolve in India. You don't come to India, as Justice Ritu Bari very well pointed out. You can apply for a divorce online. You appoint your father, brother, mother, or any family member as your GPA. The GPA appears before the Honorable Court, identifies you. You sit in the foreign jurisdiction and hold your passport. You are identified as the same person. Both spouses appear through different counsel or the same counsel in a 13B petition. First motion is recorded. The second motion may be waived or not. I will come to that in a little while. And the foreign settlement between the spouses can be treated as the terms of settlement before the Indian court, and ultimately the dissolution of marriage under the Hindu Marriage Act in your court, let us say, that settlement will form part of the proceedings and be read as a conclusive settlement to dissolve the Hindu marriage according to Hindu law, so that parties are treated to be divorced in India also. This will free them of bigamy, because there are often cases where a marriage is disrupted because it is only dissolved in the US and it has not been dissolved. So if police walks into the second marriage ceremony and says this marriage is to be stopped, such kind of a situation can be obviated. Settlement of matrimonial property in India can be sorted out. Child custody rights can be sorted out. Child custody is the worst litigation which spouses take on to take revenge against each other, not realizing the irreversible damage they do to the child. So to put a full stop to the child custody litigation, it should be decided there should be a parenting plan, there should be shared custody, there should be joint custody, or there should be singular custody. Whatever parties agree to, the matter should be solemnized, sorted out conclusively at that stage only, so that there is not another fresh round of litigation. Now, the Supreme Court has recently come up with a judgment in which they say that there is concurrent jurisdiction. So if there is a couple sitting in the US and there is a couple sitting in India, and they have moved permanently, domicile may be there, the court in the US has concurrent jurisdiction. But earlier, the view which was taken on domicile in Sundar Gopal's case was that the permanent domicile jurisdiction remains with India. So Supreme Court has a varying concept, but the fact of the matter is, as far as India is concerned, whatever arises within your jurisdiction, and Section 19 is very liberal to you in terms of accommodating a petition, particularly once there is a 13B settlement, which is arising between the parties. So with this broad perspective, I think what is very important in foreign decrees is that they can be resolved without going into a controversy of their being valid or their being invalid, because that is a procedural aspect which acquires no sentiment. Now, the question is, what happens if there are parallel proceedings between two jurisdictions? Now, this has become a very litigated area, because the moment one spouse in Australia faces an uncomfortable litigation, he runs and comes to Mumbai and files another petition. Then the spouse in Australia comes running and starts a new category of suits, which are probably not very well known in this part of the country. These are called Anti-Injunction Suits. Now, under Section 7 of the Family Courts Act, the proceeding for a suit or proceeding for an order or an injunction in the circumstances arising out of a marital relationship are within the purview of Section 7. Now, I happen to take an objection in the Delhi High Court in a matter where an anti-injunction suit was passed seeking restraint of the father to proceed with the family court proceedings in Delhi on the ground that proceedings were pending in the US. I took an objection before the High Court that this anti-injunction suit has to go to the family court because the High Court has no jurisdiction. Delhi itself, the suit was filed in the Delhi High Court because Delhi High Court is a High Court of original jurisdiction. We are not in Punjab and Haryana. Bombay, Calcutta, Delhi are suits of original jurisdiction. So the objection taken by the council was that it is a suit for injunction, not an anti-suit injunction. So Justice Manmohan interpreted it by referring to a full bench that an anti-suit injunction is a part of a suit for injunction. So the anti-suit injunction concept, which came from commercial matters, is now used in family law matters to say that between the same parties on the same dispute, the same list, two proceedings ought not to go on. And the principle of comity of courts and principle of forum convenience demands that the litigation should go on in one forum only. Now, the court in India or court abroad cannot stop each other. But the court in India and the court abroad can stop the parties before them who are same in the litigation in the other jurisdiction, not to pursue the litigation in that jurisdiction. So such type of suits are known as anti-injunction suits. So anti-injunction suits are now a common parlance because litigation is sought to be stopped. An anti-injunction is very difficult to obtain because convincing the court of the jurisdiction is a difficult task. Foreign courts tend to grant the anti-injunction more liberally. Sometimes when parties don't stop or courts don't agree, the fate is sometimes sad because there are conflicting decisions. Normally, if a court is told that the matter has reached a substantial stage, it does stop initially, but sometimes court do not agree. Now, here I wish to pause on an aspect, and I wish to develop the concept which Justice Bari raised in the beginning of counseling and counselors in the beginning. It is very important that the marriage should be sought to be resolved at a stage before it becomes ugly. In Bombay, the matter does not go before the judge till the counseling has taken place before the counselor and a report is received that the counseling has failed. Now, in Perry Consagra, Justice Lalit has authored a beautiful judgment saying that the reasons for the counseling having failed need not be recorded, but they have to be disclosed to the court so that the court can evaluate as to what went wrong. So if we were to have a counseling through expert counselors assisting the court, like we have the mediators in the High Court, where we have trained an entire set of very strong and eminent lawyers to assist the courts, maybe the infrastructure developing in your jurisdiction independently. It's up to you how I can imagine your limited resources, but maybe if the High Court were to assist with the counselors being made available to you, you would probably be better equipped in finding your feet in this issue. Now, the next issue is that how do you resolve property disputes and child custody matters in limping marriages? Now, as far as the law on children is concerned, insofar limping marriages are concerned, our Supreme Court has very clearly said child rights are never conclusive. Factors change, circumstances may differ, parties may remarry. Children are never bound in a straitjacket as far as child rights are concerned. So, even if there is a settlement, your conscience is pricked, feel free to devise methods for changing the custody issues of children. I will develop this concept of shared parenting and joint custody tomorrow in this perspective because it's a very important issue which needs to be addressed. The second issue in limping marriages come on access to children. The spouse or the parent who has a child in India in a marriage in which there is an issue deprives the other parent. So it is up to you to find ways and means. If there is a maintenance issue, stop the maintenance, do a barter, do a trade. Some resolution has to be found on the issue or as far as this is concerned. Likewise comes settlement of matrimonial property. Now, overseas, the settlement of matrimonial property is done by a 50-50 rule. Whatever is earned before marriage, whatever is earned during marriage is all split 50-50. So you have men often coming down to India to do divorces in India because they think they will have to pay less. Because we have a need-based maintenance law. We have to satisfy what is our requirement, what is our need, and according to the proportionate need, the maintenance is awarded. Now, there are situations when the spouse is earning, the maintenance is reduced down. Now, in this circumstance, a block settlement of a lump sum alimony is the best proposition, and the Supreme Court obviously endorses this process also and comes to a consensus on this issue. Now, coming to the issue of second motion, which I left there. Now, I have in my paper addressed this issue. Supreme Court in Amardeep Singh versus Harveen Kaur 2017, Supreme Court 4417 has said, we have no power under 142 to dissolve a marriage on the ground of irretrievable breakdown of marriage. The power is under 13B. And the Supreme Court says that the provisions in 13B are not mandatory. They are only directory. So the Supreme Court says, for waiver under section 13B2 and for the 6 months, Article 142 is not to be enforced. It is directory and not mandatory. It is a discretion of the family court to decide how you have to deal with this period. So if you find a matrimonial relationship has broken down as I now see brilliant judgments coming from the appellate bench of Justice Tubari, that where a marriage is over, there's no point in keeping it alive. There is no need to force compatibility, cohabitation between parties. So if parties have gone apart from the very first day of marriage and 10 years have elapsed, I think 13B is the ideal example to apply. But then what is the status of the condonation period? Do you have to wait for 6 months for the same motion? Now, this is a discretion for you to exercise. If there is a motion in the application, in the joint petition, that we have been living apart for a year already, or more than a year, or more than 5 years, we have already dissolved the marriage, I think that 6 months period ought to be condoned. Now, there is no straitjacket formula. There is no hard and fast rule. You, as the judge of your own court, you, as the legal guardian of the family, have to come to a conclusion how you will treat this, and it is up to you to decide whether you wish to condone the period or not. If you think there is a chance of saving the marriage, some relationship exists, fine. Now, we are not, there is a divide. As Justice Ritu Bari very rightly put it, every demographical jurisdiction differs on its needs, its requirements. You have a social strata under the poverty line, you have a social strata of earning groups, you have a high profile strata of double income groups in foreign jurisdictions. You can't have a hard and fast rule for every category, applying the same rule to all of them. Now, jurisdictions like Andhra Pradesh, where there are two independently earning spouses and the woman sometimes earning more, people often draw up a prenuptial contract before they leave India because they do not want to get into an ugly mess. But that is an elite requirement, and that is an argument of an exclusive category which will not apply to people. So where you find that the spouse is handicapped on account of lack of funds or resources, I think you're invoking the Legal Services Authority, which is now in existence in every jurisdiction, in every district, to provide a counsel free of cost to the concerned party can be the aim. And I think in such a situation, your requirement of deciding a Section 24 application for maintenance and litigation expenses should be a priority before deciding any other ancillary issue, because the question is only if there is going to be sustenance, be it 125, be it 24, or be the Divi Act, can the litigation carry on. So whichever party is at a distress in a limping marriage, I think ought to need the redressal on this issue. So with this overview, I come to an end. I only wish I could answer questions, but that is of course not possible. Maybe when Lord Denning decides to do a physical conference wholeheartedly with the guidance of Justice Bari, we will be able to exchange views and thoughts and have a dialogue to exchange views and learn from each other. Thank you very much.